Hello, everyone, and welcome back. Today, I'm sitting down with Rana Chatterjee, head of company and commercial at London-based law firm Colman Coyle. So today, we're going to talk about commercial contract agreements and a lot of not just what to do, but what not to do. So I'm going to let Rana introduce himself, please.
Everyone. My name is Rana Chatterjee, as Jennifer said. I've been working with commercial contracts for around the last 20 years with a range of businesses from startups to public companies. I also work with corporate matters, things like share purchases, mergers and acquisitions, as well as some work with data protection and technology.
Okay. Who would benefit from listening to this conversation today?
I think commercial contracts really affect all kinds of businesses. I think with respect to the subject of this particular podcast, perhaps the smaller and medium-sized businesses are the ones that tend to fall foul of not paying enough attention to their commercial contracts. And that, as we get into, can lead to lots of issues. The larger companies tend to have complicated law firms and lots of the work with commercial contracts gets checked a little bit more thoroughly. But for those clients that don't necessarily have those resources, it's much more of a challenge. But really, as we'll see, the failure to properly look at commercial contracts isn't something that's just limited to smaller companies. It can be something that gets in the way of really big deals as well. The nature of commercial contracts is that they can affect all aspects of business. Obviously, there are one or two individuals, or in larger companies, one or two departments that will have the focus on making sure the commercial contracts are right. But their effect really stands to benefit or negatively impact all parts of an organization.
Okay. And what are the basic parts of a contract or the process, and when should legal expertise get involved?
Normally, your contract would have who it's between. It would have the nature of the contract, i.e., what party is providing to the other and what they're getting in return, usually payment. And then you have some kind of a signature at the end. That forms the basis of most contracts that are agreed. But obviously, there are things that need to be considered, and most often the things that go wrong aren't around those kind of fundamental issues. They're more around what happens if one party doesn't pay or one party doesn't provide the services they were supposed to, what happens if other things go wrong. For example, there's a global pandemic, or if one of the parties goes bankrupt. There's a kind of whole myriad of things that can be an issue in the future that the people that are putting the contract together haven't necessarily thought about. But obviously, to put a caveat in, no one can ever really anticipate all the things that could go wrong.
But it's 2026, and unsurprisingly, we're seeing a big pop up of AI law firms. What are the risks if you just use AI? Because especially a lot of founders are tech. They love they love an AI solution. It's much quicker. They don't have to talk to people. What are the risks with that?
Yeah, it can be a really useful tool, and lots of lawyers are using it themselves, although obviously they have to be careful, as do we, with some of the more open-ended AI that aren't necessarily protecting client data that you might be sharing with it. I suppose I was talking to somebody about this the other day. I think one of the main issues with AI, as people are finding as they use them more and more, is that they tend to have a focus on telling you what you would like to know, the things that would keep you coming back. So that the function of AI is to ensure that you continue to use it rather than to go on to other sources like books, if people are still using books, or actual human lawyers. And what that means in practice is that you might not necessarily get the whole story. Obviously, hallucinations, which has had a lot of publicity recently with some of the larger kind of AI models, has been an issue. And we've certainly found it when we've done test research using AI tools in our office, that it will come up with legislation and case law that doesn't exist. And so I suppose that the accuracy level of AI at the moment is perhaps, and somebody may correct me, but it seems to be between 80 and 90%. We're likely to get beyond that at some point in the future, but for now, that kind of 10, 20% is a risk that probably isn't worth taking if what you're looking for is definitive legal advice on your position around a commercial contract, or indeed for an AI tool to draft it from scratch. If there are errors in it, then those can really only be picked up by somebody that has experience of looking at it, and probably somebody that's human. So it's not that AI can't be useful. It's just that when it comes to things like this, when it comes to legal advice, you obviously have to proceed with caution.
Let's talk about more of the common mistakes you see nowadays across business contracts.
Yeah, they vary, I think, across sectors and industries and types of business. There are some things that keep coming back. As I said, things that the business owners, whoever's responsible for drafting the contract or developing the position that a company is going to take on contracts, neglects to properly think about or to detail. But as we'll see, there are also things that come up with contracts that could come up even if a great deal of work was done on them. They are just things that sometimes get missed. I suppose what we see regularly are things like payment obligations. So where most contracts will contain some element of a requirement to make payment one way or the other. When payment is due, who is required to make the payment, and things like currency or bank accounts to which payments are to be made. If they're being made by a third party, then that third party has to be involved, and their approval or their agreement to the arrangement has to be secured before the payment obligations are really binding. And those obviously really fundamental nature of most agreements. And what we're seeing a lot lately are things like liability. In the last, I suppose, 15 or 20 years, this focus on limiting liability of a particular party under an agreement has had increased focus. Parties are keen to ensure that where they have contracts with multiple suppliers, that they're aware of what the risk position is under each of those contracts, and you can really only do that with limitations of liability clauses. If it's unlimited, then and there aren't any restrictions on what can be claimed for under the contract, you can see claims spiraling out of control far in excess of the value of the contract itself, for things like loss of profit, loss of opportunity that can sometimes be permissible as a claim under these contracts if they're not properly managed and those limitation of liability clauses aren't looked at. Other than that, we've got kind of the scope of the services, which people have to be clear on who owns things. So under intellectual property rules, where information is being shared, is ownership of that information being passed across as part of the contract, or is it remaining with one party or another? What happens if things go wrong, as I was saying before, the default provisions, if payment isn't made or if services aren't provided, what are the rights of one party to make a claim against the other? Those are probably the ones that we see most often, but there are other ones that are kind of the smaller, slightly more of a trip hazard in some of these contracts that you perhaps think that aren't as useful, but once they come up once or twice, you realize that actually no part of the contract is really something that you can do without, because there could always be something that comes up if your luck is that bad, that means that you'll kind of have to face the consequences.
Can you make it a little more tangible? Because a lot of the founders on the call may know theoretically what can go wrong, but can you give some examples of what happens if a deal goes wrong?
Yeah, sure. So I mean, what can happen is, say, for example, in a real world scenario, you've got a supply chain, you have service levels for, let's say services are being provided from company A to company B so that company B can provide services to company C. In those, so in those situations, having a contract that works through the chain is really important. So if we look at things like service level, company A has a particular service level to provide to company B. It's required to, let's say for argument's sake, it's an IT contract, and the timing for response to a query for company A to company B is 3 days, three working days. But then company B's obligation to company C requires them to provide solutions to those issues within 48 hours. And then so you have this disconnect between what B is obligated to provide to C and what B can feasibly make a claim against A if it fails to provide. So those are the kinds of things that we might need to look at. I was giving the example of payment terms before. So I suppose kind of a more specific scenario that you that it makes it clear that party A is providing services to party B. In return, party B is obliged to pay party A the sum of £50,000 for those services. But what the contract doesn't say is whether or not that amount should be paid only when an invoice is sent from B to A, or they should be automatically payable at the end of the period of services. And it maybe doesn't include the bank account to which that payment needs to be made. Some of these things can be cleared up. You can have communication and details can be provided. But what we see tends to happen a lot is that once the contract is signed, all the parties that are kind of responsible for this work tend to kind of drift away, and then getting those details back together. So, finding out who that to make the payment to. So say, for example, your company B, you know that you've received services from company A, and you would like that you would like to make payment for them because you know that you're contractually obliged to, and more than anything, you think that was the deal in the first place. But you don't have a bank account to pay the services to, so you call up company A and you say, we need to understand which account to send them to, and company A says they'll get back to you, and then it's been a week, and then what happens? Is it company B's obligation to make sure that they chase up whoever it was that said they were going to get back to them so that they can make payment? They could be excused for saying, well, we've asked the question. If they don't tell us, then they can't very fairly say to us that we're defaulting on our payment obligations because we've told them why we can't make it. And also, the timing of invoices. So, if the contract says the payment has to be made within 30 days, but the invoice requires payment within 15 days, then which of those is the one that the payer has to abide by? Is it the 15 or the 30? And lots of these details can be cleared up by proper drafting of contracts. Like I said, thinking about what could go wrong, thinking about the potential areas of risk, and trying to manage those as best as you can.
And I always assume it's the contract one. As freelancer, when I invoice, I didn't even bother including a deadline date because it felt fictitious. It always felt like, well, it's whatever was in the contract if I had a contract with someone. So it
Yeah.
seems like wishes, and maybe it's a good idea to put pressure on, but no one's paying attention to that.
Yeah, when I was contracting, I did the same thing, because what tends to happen is that you're beholden to the supplier's own payment terms. So you could put an invoice in that says, I require payment within 7 days. But if the payment terms that they generally operate, the company that you're asking for payment from, if their payment terms are generally 30 days, once they receive the invoice, then it makes little difference what you put on your invoice, because unless you're going to try and force them to pay within a shorter time by taking them to court, then usually you just have to wait, like all their other suppliers, to be paid in accordance with those terms. So it can be really problematic. Lots of these things that go into contracts can be enforced, but I suppose the overriding thing is that there are policies and processes that sit alongside them. And whilst the contract gives you the right to make a claim or things that are in breach of that contract, I know that lots of companies, particularly where there's a mismatch in terms of size, a larger company contracting a smaller company to provide services, the smaller company will often just have to live with what the larger company says, because forcing them to comply with the terms of the contract is not something that's financially viable, and also they're worried about burning bridges. So that's kind of the undercurrent of all of the conversation around what goes into a contract, is that enforcing them is perhaps perhaps not as easy as it should be. But maybe that's a subject for a different podcast. How to make a claim under a contract when it means that you have to go to court with all the kind of fees and hassle that's involved with that.
Absolutely. That's why it's definitely better to get things up front and hopefully work with trusted partners that it can happen.
I think that always, as a lawyer, when I'm writing contracts, I think every drafting lawyer has had the same thought. Who's going to read this? You have deadlines, you have clients that are asking for you to produce the contract, you have bosses to answer to. But if the feeling is that the contract's going to go into a drawer somewhere or onto a website and sit there hidden behind a few links as terms and conditions that no one's ever going to look at unless something goes wrong, in which case they'll be looking to see whether or not you've done your job properly.
Absolutely. Is there anything else you wanted to talk about today?
Yeah, I mean, I thought that maybe some examples of things that could go wrong. That there's a fairly well known case between Rogers Communications and a company called Bell Aliant, and this was around cabling and kind of use of telephone poles to lay cabling. I think in Canada was where at least one of the parties was based, and the dispute with them was over when either party was allowed to terminate, whether or not, because there was an initial 5-year fixed period. And then there was mention of a right to terminate with 1 year's notice. And the question was whether or not that 1 year's notice could be done any time after the 5 years, or it could be done even during the 5 years. And it came down to where the comma was placed in the termination clause, because that changed the interpretation depending on who was reading it, I suppose, of whether or not that 1 year applied to the 5 years or it only kicked in once the 5 years was complete. And had the comma been put in a different place, I think that, or if the drafting had been completely different, that question could have been resolved. But in the end, I think that was something that cost one of the parties 1.5 million in terms of the lost revenue from that particular deal. I think Rogers ultimately was successful in that they argued that the 1 year notice couldn't be given during the initial 5 year term. But it is an example of how the smallest details in contracts, as I was saying, even if you have lawyers working on it that think that they have done a good job, there is enough doubt and uncertainty around some of these provisions that there can always be something that trips you up. So it's always worth kind of being really diligent and being, I suppose, a little bit over risk averse in order to kind of avoid those kinds of problems. We've seen kind of commercial contract issues arise for companies as big as Sky. Obviously, the issue that came up recently, what's been a big story in the UK between the UK Post Office in their Horizon project and the services provider that was IBM. I think lots of the discussion there, aside from the issues that the postmasters had faced, the kind of aside from the human element, there was a real commercial dispute between IBM and the Post Office around the contractual framework. And, who was responsible for the technical governance and the operational failures. So it does really spread across all kinds of companies, irrespective of their size. So something it's always worth being really careful about.
Yeah, absolutely. And this is where you work with, I guess, cross border contracts as well, adds another layer of interpretation and complexity.
Yeah, I mean, you get this across different courts within the same jurisdiction, just different judges, different people reading them, applying different meaning to the same words. That's kind of heightened a lot when it comes to courts in different jurisdictions who will often provide a different interpretation of the same clause just because the context for it in their country and in their kind of jurisdictional system with the history of their commercial agreements is different. And something else that becomes a problem is where contracts are written in a language that's different from the native language that the court might be using, and then you have interpreters, translations, and that's where things can really go off the rails, particularly if there is disagreement over what words mean, even when people speak the same language. So I suppose that it's not an exaggeration to call it a real minefield. And like I said at the start, there's perhaps no way you can ensure that everything is perfect and completely future proof, but there are things that you can do. And one of the things is to ask a human rather than to use AI, just because I think the propensity for those kinds of issues to occur probably amplified a little bit when it comes to computers.
And we're just going to see it more making headlines, I think, soon.
Yeah,
So,
I think.
if people want that expertise, how do they get in touch with you?
Well, the easiest way is probably to email me. My email address is on the Colman Coyle website, but otherwise it's rana.chatterjee colmancoyle.com, or if you prefer to call, my direct dial number is 0207 704 3453.
Thank you, Anna, and thank you, listeners.